What an infuriating and sad day. I guess all the baby oil paid off for P.Diddy because he was too slippery for the justice system. I cannot believe it. They have now reached a verdict on all the charges, and he has been acquitted of the most serious ones. The Lord of Lube wiggles his way out of it somehow.
And after nearly a 2-month trial with 34 witnesses and hours of salacious testimony, a jury of 8 men and 4 women finds Sean Diddy Combs not guilty of racketeering and sex trafficking, but guilty on 2 counts of transportation to engage in prostitution. The judge is currently deciding right now whether Combs will actually be released today. His defense arguing that since the music mogul was acquitted of the most serious crimes, he should be able to go home. Once court was adjourned, family members cheered today's verdict. Combs' son, Christian, telling ABC News how happy he is.
Hey, yo, we love y'all. We love everybody watching. So happy. Pop's coming home. God bless. God bless the whole world.
What was going through your head when the verdict was read? Happy.
So the Diddy verdict is in, and he was found guilty of 2 charges and not guilty of 3 of the other charges. But what does all of that mean? He got cleared of the RICO and the sex trafficking charges. Those were the bigger charges. Those were the ones that the prosecution really wanted. Those were the ones that would have carried a lot of time. What he did get convicted of was the Mann Act. He got hit with 2 charges of that. And what that is a federal case involving prostitution where you're transporting people across state lines. Now, some people on here are coming out and they're saying that there's a mandatory minimum of 10 years. That's only if it involves a minor. And this was like Cassie and like some anonymous lady named Jane that is one of Diddy's exes. Neither of them are minors. There's no mandatory minimum here. He's probably not going to prison. They're definitely going to be seizing his plane because he used that in transporting these people for prostitution. One thing about the feds is they love to seize any and all of your shit that they possibly can. So if they can prove that you utilized it in any type of a crime, they're going to take that from you. They also brought out all of his bank records and proved that he had used his banks to be able to pay for this stuff. So they might be seizing his bank accounts, but he's got bread outside of that for sure.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye. Here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms. Allen is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly, and so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed, substantive questions, let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, as to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was the traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Brian Khoberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defendant's car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor, it was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walenta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, this Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through sentencing.
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume that the trial date will be vacated and those 4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Good morning, everyone. Today is July 2nd. Magistrate is back. Judge Pattison is still off this week. And we have a very slow day. Kind of dressed down a little bit today. We have a total of 2 arraignments and 3 pretrials. I expect both of our arraignments are going to be not guilty pleas and appointed counsel. And that's it. Jeanette Jackson is here with us from the Public Defender's Office. We did end up having a fairly busy day yesterday with the morning and afternoon some other things, but today is very light. Maybe it's the 4th of July vacation week. Tomorrow's not much better, to tell you the truth. So things go in spurts. We have a population of 95 at the jail this morning. I may need to fit in a few jail arraignments. We'll see how that goes. At any rate, we're here, ready to go. While we get some customers. Good morning. What's that? Yeah. Good morning, Mr. Eek.
Good morning.
All right, we have two files before me. Christina May Drake filed 25343OM as a retail fraud under Sturgis ordinance that allegedly occurred on March 25th of 2025. Under Sturgis ordinance, retail fraud is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Second count, trespass, 25344OM, Sturgis ordinance, also 90 days and or $500. The Sturgis City Attorney, Mr. Tim George, is here. He's agreed to dismiss the trespass charge if you plead to the retail fraud charge. Ms. Holmes, I'll be with you in a minute, all right?
Yes.
It's alleged that you were at 400 West South Street. I'm not sure what that is. All right, Ms. Holmes, Ms. Drake, this is Jeanette Jackson. She's from the Public Defender's Office. And Mr. George, as I indicated, is from the city. You've been in jail for 5 days for this. My inclination is to give you time served, but you have another case.
Can we do it all at once? Or does it have to wait till tomorrow?
No, we can do it all at once. 1147. The other is that on May 5th, you're in the gas station. Two bottles of liquor. Gentleman Jack and Bacardi line. So that's also a retail fraud. It's punishable by up to 93 days in jail and a fine of up to $500. You are really struggling. All right, so Mr. George would dismiss the trespass charge if you plead to the retail fraud charge in Sturgis. You also have the other retail fraud charge from White Pigeon under state statute.
Sir,
And
I
that's set for
just want to say, I am working. I have been able to obtain a vehicle, and I'm already I've already applied and been accepted through SNHU. I'm going into a recovery coach program. I'm trying to change things in my life, and I feel that would be my best option, is to get into a program where I'm working with others who are struggling in the same area I'm struggling in.
What is your main problem? Alcohol?
Yes, alcohol.
Didn't you work at Doc Foundry or something at one
No.
time?
No,
That's a different age.
but
All right, so are you
I-
willing to plead to these charges?
I am, sir, but if I'm kept too much longer, I'm not gonna be working or have that.
Where do you work?
opportunity. Well, I've been working, like, I've been self-employed, but I've been helping clean out, storage units in Bronson, and, they have some more in Coldwater. But if I'm, right now, because of the holiday, it's not really gonna be a big issue. I'll be able to start working again, and I know that these are financial crimes, and I really just wanna get back to work and start paying back my debt. And like I said, I really feel that if I can get in a program where I'm working with people who are struggling, the same struggle I am, like this program through SNHU, I really feel it would help keep my feet on the ground and making strides in positive direction.
You're a mess.
I am.
And everything you just said is a bunch of words that really have some substance, but
I was able to buy a truck. I'm just working on getting money to get it legal. And I mean, I know that it doesn't really mean too much when I'm sitting here facing 3 charges, but I am.
and you've got a felony charge in circuit court.
Yes.
That was bound over in May, and you're on felony bond, and you're still out stealing stuff. Now the one was in February. You didn't show up.
That was because I was locked up in Elkhart.
All right,
And then the next time that I had court in June, I messaged my lawyer and asked him if he could get it like rescheduled to when my next court date was on the rest of my stuff because of work. And it said that he got the message, but he never responded to it. So I attempted to do something about the one in June, but it was because I was working.
All right, who lives at Congress Street?
My husband.
So are you
And
there?
children. Not at this time.
So are you still homeless?
Technically, yes, but as soon as I get this truck legal, I can get a real job, like, on the books. That's what I've been working towards. I got this F-150, and now I just got to get it legal, and I can get a job that's, on the books, that I'm punching a time clock. And I really am trying to hold myself together. Like, when they picked me up, I wasn't on anything, and I was proud of myself that, even though I was going back to jail, that I was clean. I didn't have any alcohol in my system or in my possession.
When did you get picked up?
I'm sorry,
When did you get picked up?
last Thursday.
How did you get picked up?
I was walking down Centerville Street. I had just had dinner at the park with a friend, because they have them girls at the park. And we were walking back towards my brother's. I'm not technically homeless because I've been living with my brother. I haven't been living in the homeless communities or anything, but I don't have a home of my own.
You're not welcome to come to your husband's house.
No. We've been separated for about 9 years. But my brother lives in the trailer park in Sturgis, and the one behind Granby's, and that's where we were walking back to when Officer Ware seen me, and I had the active warrant.
And you knew you had active warrants.
Yeah, so he came and picked me up. I didn't know I had active warrants. He said it had just come out 2 days before that.
Well, you didn't show up for court on
Right.
a couple of different occasions.
Well, that like I said, I messaged my lawyer, so I wasn't sure that was even a warrant. Because I messaged my lawyer and asked him if we could reschedule it for when my next court date was, because I was working at, and was able to obtain this truck. And I apologize that I didn't call the court myself, but he had told me if I messaged him, that he would get it, and that anything like that I just thought.
Well,
he
that's
would
in
take
your
care.
felony case. You don't have a lawyer in these cases.
Well, I didn't know he couldn't handle the others. Sorry.
All right, well, are you willing to plead to the retail fraud from February? Where was that, Mr. George?
It was at Meyer and Sturgis.
What would I be looking at time wise, do you know?
1,000 days plus 4 million after that. I don't know what to do with you.
I know.
You talk a good game, but you got multiple theft charges. You're bound over to circuit court on a felony case of theft. You don't show up when you're supposed to.
I've been
You're like
checking
Tracy
in. I was
Chapman in
checking in
Fast
with-
Car. Things are gonna get better and you're gonna move out of the city.
Well, I've been I've been checking in with community corrections. I mean, I've been doing everything so that I would be holding myself accountable, sir. And I apologize for my mistakes, but if you'll give me the chance, sir, I'll show you I'm really meaning what I say. And with me checking in with community corrections, if you don't feel that the steps I'm taking, if I'm released are in that direction, I mean, you know, I can always be picked right back up, just like I was.
That's always true.
And I'm not trying to pull the wool over anybody's eyes. I'm just trying to do better for myself, my children.
Now, at one time you were struggling with meth. Is that not a thing now?
That's not a thing now.
But I don't think you have a valid driver's license.
Yes, I do.
Do you?
Yes. I actually just got it in the mail, because my husband has been keeping my mail for the past 7 months and I didn't know it. And so every time I would have stuff sent there, he wouldn't give it to me. So I had my mail held at the post office and I have it in my personal belongings. Yes, sir. I do have a valid driver's license. But even a restriction on that can make sure I don't go too far out of the, too far out there. If when I do get this drug legal or something, I don't know. I'm willing to work with you. I just want to keep making steps in the positive direction, sir.
What do you have an L card?
It was a public intox. I did 5 days on.
Well, we were looking for you on 2024-52, resisting, obstructing, yield fines and costs. We talked to your ex-husband, told us you were in Elkhart County Jail.
Yeah, I had been at one place drinking. It was the day after my dad went to jail, and my dad's girlfriend insisted I come back to their apartment. So I went back to their apartment and an officer picked me up for being drunk in public intoxication. And so I did 5 days there.
All right. Do you wish to plead to these charges or not? I'm not. All right. So let's talk about the first one. Anybody threaten you to get you to plead to that ordinance case from Sturgis?
No.
In February at Myers?
No.
What did you take?
I don't even remember, sir.
Can you tell us, Mr. George, what it was?
It was a number of items. I think there was some nails, a hammer, some extension cords, and some food. The total amount was $157.12, but it was all recovered.
Hammer and a hip. My smells clean. All right, so do you acknowledge that?
Yes, sir.
Do you understand, Ms. Drake? And this applies to you as well, Ms. Holmes, if we enter a plea in your case. Do you understand that if you plead any of these charges, to have a trial in front of a judge or jury? Do you understand?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Attorney, you had to do is ask for you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf. You have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be innocent. The state would prove your guilt beyond a reasonable doubt. Understand?
Yes, sir.
We're
May I ask,
Yes.
With the hesitation on me being back out in the community and everything that I'm saying, what if we do a probation for my misdemeanors? You know, I'm still awaiting this felony too, but what if we do a probation where I'm
Well,
checking in?
I may try to
regularly?
figure that out, so let's talk about that.
Okay.
All right, so, and I think finally you have a right to be presumed innocent unless the state we are guilty beyond doubt. So let's take straight up front.
Because I really think probation would be the way to go on making sure that I'm being held accountable and that you're not just letting another criminal back on the streets to commit more crimes. I understand that that's how it goes. I completely understand that.
All right, I'm gonna order in that one 5 days, credit 5 days. Minimum fine of $120, 2 days. 7-2. Concurrent with the other retail fraud, which is 2-5. All right, let's talk about that one.
Okay. In that case, sir, I'll tell you exactly what happened.
All right, well, let me get to it. That case.
I was with a
Well,
woman.
slow down.
Okay.
Alleges that you were in the Shell gas station on May 25th.
I didn't even know that they came after me with these charges because
All right.
I wasn't aware.
So did you take something?
Well, that's what I was gonna say. I wasn't even aware that they were coming after me with these charges because I wasn't aware that they looked at me as if I had taken something. This woman said she wanted to get these 2 bottles and she was up at the register paying and I grabbed them and they knew I grabbed them and I walked out of the store with them. Now, I didn't realize she didn't pay for them. So I wasn't aware that they were coming after me with these charges, but I did not, I was in her truck. I mean, they didn't even come out and say anything. Nobody did. I just went out to her truck, but I did walk out the store with them, so I will take the charges, but it wasn't for me. It wasn't even anything I intended to steal, sir. I just didn't realize that she didn't pay for everything.
Stop.
I'm not making excuses.
Yes, you are.
No, I wasn't.
Stop.
What, okay, what did they say?
I was interacting with Drake and Nickerson at the same time. Nickerson said she wasn't sure who Drake was. She was a friend of a male subject. I asked where Drake went. Nickerson said she thought she had left. Then they told the lady not to come. Then they watched the surveillance videos, showed several angles from several cameras. The second video of the liquor aisle at 417. In the video, a subject enters the liquor aisle. That's you.
Yes.
The subject removes the gentleman jack from the shelf and puts it in a large black handbag. The subject moves to the Bacardi Lime and removes it from the shelf and places it in the same black handbag. The subject then moves to the back of the store to an empty Subway shelf and adjusts the bottle so they cannot be seen. Subject walks to the Subway counter to get something from the clerk, and when she returns, it's Christina Drake. So, do you want to admit to stealing these 2 bottles of liquor? Or do you want to tell me some goofy story about
No, that was
All right.
That was my understanding of it, was that she was paying for them, but I admit, I am
Stop,
admitting.
stop.
I am admitting to stealing.
All right.
bottles.
Okay. All right. Anybody threaten you to get you to plead to that one?
No,
All right, you're barred from Myers.
Yes.
The other one, you're already barred from Myers. In this one. This one. This one. Get the file straight. Same thing, 100 additional days. I'm gonna order 30 days, credit 5, leaving 25 days to serve. You're recommending a probation. I'm gonna see if I can find some sort of placement for you in a treatment.
sorry, what was that?
I'm gonna see if I can get Pivotal to find a placement program.
Okay.
30 days, credit 5, may be released to treatment program.
Thank you, sir.
I can't, you're just gonna be in jail for a while. Now, you got a felony case thing for other thefts. They felt seriously enough about it to bind it over to circuit court. I'm not sure what the plan is there. You're barred from Shellmart. Pretty soon you won't be able to go in anywhere.
I know. I'm working on changing that, sir.
Plus, you had so much license baggage. I'm amazed that you got your driver's license back. Michigan license?
Yes.
All right. I'll send an email to the jail pivotal coordinator and see if they've got any ideas. Otherwise, if they can't find something, you may just sit for the next 25 days minus good time. Should be about 21 days. But I was disappointed when you were still tap dancing around the fact that you just stole this stuff and you weren't. So you're so much alcohol over so much time has compromised your brain. 5 days clean is a good start. So we'll see. I'm going to email the jail and see. So someone may be coming to see you to talk about options. All right, you're good to go. Did either of the other guys show up? Good morning. Are you Janaja Holmes?
Yes, good morning.
This is Judge Middleton. I'm here at the court. Also with me is Jeanette Jackson from the Public Defender's Office. You've been on a roll and it's all downhill. So let's talk about this. File 212378 OT is an old driving suspended case. You were charged with driving suspended in November of 2021. You got arrested. They appointed an attorney set a pretrial, you pled not guilty, they set a final pretrial in February of 2022, and your lawyer was Tim George. Well, this can't be right, it's an ordinance case. Oh, this is before you were the city attorney. So we got a wrinkle here. John Barnes was the city attorney. Anyway, we lost track of you and there was a warrant out for you for several years. Then you got charged in a new case, retail fraud, from November of 2024, and you got picked up last night. Let's figure this out. So, Ms. Holmes, when did you get arrested?
So this was yesterday.
Where?
I was actually on my way home, and the person that was driving got pulled over, and I was in the passenger seat, and I got arrested for my warrants.
All right, where is home?
Three Rivers.
What's your address? Still the River Road address?
Yes, 18211 South River Road.
Where have you been for 3 years?
I've just been working. I haven't been in trouble. I haven't been doing anything really stupid.
Where do you work?
Peterson Spring.
Do you have kids?
Yes, I have an 8-year-old. He's with his dad right now for the rest of the summer.
So they just pulled this guy over, found these old warrants for your arrest.
Yes.
And picked you up. All right, well, this is living proof that ignoring things doesn't make them go away. You just blew these off. We had a lawyer, we had a trial, we were ready to resolve the thing, and then you just didn't show up. Then you got caught stealing something, or allegedly, and then you didn't show up for that either. So I'm going to let you out of jail on your promise that you will show up for court. One option, I could just leave you in jail until the next available date, which is August 1st. So I could leave you in jail for the next 27 or 28 days, and then we'll deal with it. That'll make sure you show up. We're gonna have to get a different lawyer for you. I'm gonna appoint attorney in both cases. Luke, well, yeah, in both cases, because Tim George can't represent you. The original charge was only driving suspended. Mr. George probably was about ready to work out some sort of plea agreement, and then you didn't show up. I think I even called you on the phone without any luck. Does your phone number end in 9297?
No, I have a new phone number.
8627?
It's 370.
Right. No, don't tell me on here. You'll start getting random phone calls. All right. So appointed attorney in both cases. Tim George has conflict. I did this arraignment this morning rather than have the magistrate do it this afternoon. What shift do you work at Peterson Springs?
First shift.
So you're missing work now?
Yes.
All right. I'm gonna do attorney pretrial for 8/1/25 at 8:30. I'm gonna set bond of $250 PR in each file. Blowing these off has not been a very successful technique, so let's face them head on.
I agree.
And we can get these possibly resolved by August 1st. If they can't be resolved, you can have a trial. I'll have a lawyer help you with it, but ignoring it ain't helping. All right, so you're gonna get out of jail. We're gonna give you some paperwork with your new lawyer's name and number on it. I want you to call that lawyer and discuss it with them. Tim, I'm not sure what the conflict on the earlier case, because you had represented her as a defense attorney and now your firm is prosecuting her. So you might have to transfer that to the county or something.
Okay.
But you can handle the retail fraud.
Yes, sir.
Anyway, Miss Holmes, you're gonna get out of jail. You're gonna show up for court. I'm gonna see you on August 1st. There'll be about 412 other people that day. It sounds like it's gonna be a busy day. So it's important that you call your lawyer and discuss it with them first. Have you got somebody that'll come pick you up?
Yes.
All right. You're gonna get bonded out here this morning. You're good to go.
All right, thank you.
All right, thank you.
I overheard something about how you may not be able to represent her. Are you gonna reach out to Keith regarding that? In case we have to reassign?
We do have to reassign.
Okay, which,
He's on the traffic case.
so the DWLS?
Yeah, so just appoint a new lawyer on the retail fraud, and whoever you appoint him on the traffic case also.
Okay, so you, okay.
The court will call the matters of David Jordan, case numbers 22W003051B and C, as well as 22W005875 and 24W000699A and B.
Paul Barnett on behalf of the township.
Please state your name, Mr. David Jordan.
David Jordan.
Thank you. We're here for show causes on these tickets. So, Mr. Jordan, you were in MDLC for a while?
Wayne County Jail.
Wayne County Jail, okay. I remember that there was some, I gave you some, for the criminal cases, I gave you jail credit. And trying to make sure they did what I asked, which was something, they posted a bond and I had moved it to pay on the ticket. Isn't, let me see, 24W000699A. They display a license. I don't understand why this hasn't happened. I'm sorry, what? Yeah, I don't understand why it hasn't happened. I don't understand.
So, sir, you owe a total of $917 still. Wait, but one of these is no proof, no proof. Failure to display a license. So that's not right either. Minus 252. Mr. Jordan, do you remember when I gave you jail credit, how much jail credit I gave you on the criminal matters?
No, I don't.
Okay. 1 second, let me look that up. How long were you in the Wayne County Jail?
90 days.
I'm just gonna give you 30 days credit time served on the 24W000699A ticket. Fines and costs are waived. So that one. So you owe 665 still. Do you need a payment plan for that?
Yes.
Okay, and that's on the note of insurance ticket that I can't do jail time for, the no registration that I can't do jail time for, the loud noise ticket that I can't do jail time for.
Okay.
And another no proof of, no, that's just a clearance fee, and an improper lane ticket. Okay. I am someone's gonna finally figure out how to add this $210 bond that you paid to one of these tickets. So that will take you down. When I give you credit for the 252 on the failure to display a license, when I take that off, because I just gave you credit time served on that one, and I take off the 210 that the bond that you posted, it brings it down to $665. So how much can you pay per month?
Right now I'm not working, so I'm really not sure.
All right. Are you looking for a job, Mr. Jordan?
Yes.
Mhm. Do you want me to bring you back again to see if you've gotten that job? I know you just got out of jail in the last 2 months?
Yes.
Okay. Do you want me to bring you back to well, I see. I'll bring you back on September 3rd, see if you have a job, okay? September 3rd at 10:00 a.m. We'll see where you are, Mr. Jordan.
Okay. Can I ask you a question?
Certainly.
So because I know some of the actual tickets I had paid. So I'm just trying to keep up with what's going on right now.
None of these tickets are paid, sir. I wouldn't be telling you that they're
Ma'am, I have my receipts. I tried to explain this to you before.
I know, but those are different tickets, not these ones.
Correct. Mr. Jordan has 17 matters.
You had 17 tickets. These are the ones that are left.
Okay, so what I was trying to explain is like when he wrote me the no proof of insurance, which I had insurance, when he wrote me that driving on suspended for that particular ticket, you had told me to pay the driving on the suspended parts, and I did that. The only thing that I thought that I had left was the civil infractions.
The driving while license suspended is the one you put $210 on, sir. And I just told you that I'm transferring that $210 to some of the civil infractions and giving you credit for time served on the driving while license suspended. So your $210 can go towards one of the civil infractions, and you can get credit on the driving while license suspended. This is the same thing I explained to you last time, unless you want to just put it on the driving while license suspended, and then you'll owe another $210 because that won't be credited in two places.
All I said was I was trying to understand what was going on.
And I explained it to you 3 times now.
Okay.
Do you understand it yet?
May I have a court date where I can actually come in? Because I would like to pull the transcripts. I'm being honest with you because I have been trying to only explain myself when I be on Zoom. And then when I try to explain to you what me and you talked about from one court date to the next, you tell me that I'm lying to you, and I have never lied to you about what you have told me.
Say that you do not understand. You are not hearing and you are not listening. You can pull.
I'm talking about previous court dates.
Stop talking over me, please. You can pull whatever transcript you want to pull. That's up to you. You're not coming in. This is in. If you want to pull a transcript so you can review that, you go ahead. You can call them and find out how much it costs to get those transcripts. That's up to you.
If you're not, it don't matter. It don't matter.
I think you don't listen well, is what I do think.
I do listen well. Miss, what I'm trying to explain to you is it was like 4 court dates ago, and we had a conversation, and you told me something, and I'd done that. And then when I came back to court, I tried to tell you that, and you told me you never told me that. I have went through this with you a few different times. When you asked me why was these tickets so old and still pending, I told you because every time I came to court, the prosecutor always said that they want to see if I can get my license, and they set them aside.
Why don't you go ahead and pull the transcripts so that you can prove whatever it is you think you're trying to prove, Mr. Jordan?
All right. I don't see why, nothing. That's just, all right. So, how much?
You just told me you were listening, so you should know the number.
You said 6 something.
$665.
You write this down. Yeah, I mean, I'm being respectful. I don't even understand why you even getting an attitude with me.
Well, maybe if you go back and watch the video, you'll understand it.
I do. Ma'am, you was my lawyer on these cases.
I was not your lawyer on these cases.
All right. Okay.
Do you understand you've had 17 tickets in this court?
Yes, ma'am.
So why are you saying something that is totally not true?
I'm not lying.
Okay, whatever, sir. You know what happens on a docket? It shows who the attorneys are. I was not your lawyer on any of these tickets, Mr. Jordan. Maybe you should stop getting so many tickets and then you wouldn't get them confused.
All right.
Anything you want to talk about today, Mr. Jordan?
I mean, nobody listens to me, so I'm a compulsive liar. So I mean, I don't know anything I'm speaking on. That's why I asked, can I just come into the court on a live instead of doing this over? I have better court dates with you in person.
I'm about done with this docket with you today because you do not listen. I already told you 3 times you're not coming in here into this courthouse. If you want to get a transcript, you can order that. I don't know what else.
I understand that. I heard all that.
And well, then stop saying you're going to come into the courthouse because that's not happening right now.
You already said that too.
From you. Mr. Jordan, in a few moments, you're going to be held in contempt of court and you're going to be doing some additional jail time. Is there anything else you need today?
No, ma'am.
All right. Then you have a great day. Goodbye.
Thank you, Your Honor. Court calls case People versus Vincent Dunlap.
People.
I think Mr. Stiller's on some of the other cases, but.
Conrad Siller on behalf of Pittsfield Township.
Sorry, Mr. Stiller, handling a bunch of stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
Good morning, Your Honor. The please this honorable court, Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right. And what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all three cases to the civil infraction of a double parking.
That's correct, Your Honor.
Yeah, there's a state case that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. Jail fraud case. I'm only a prosecutor for the EWS case.
That's why I thought I spoke with you earlier. Awkward.
Well, it looks like we do not have an agreement.
Then, Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back. Last time we adjourned it to see what was going to happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
My cases are the cases with Mr. Stiller, Your Honor, so I would, we are going to.
Double parking on both.
Correct.
And double parking in each case, Your Honor. I'm going to move that count to in each case, double parking. If you accept that admission deed in each case, and it's the original charge in each case.
That's a correct statement.
That is, Your Honor. Thank you.
Dunlap?
Yes.
In case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
On the case ending in 354, on the date of April 2nd, 2021, do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes.
Court will accept those admissions in each case. Count two. Count one is dismissed. In each case, fines and costs are $180, so that's a total amount of $360. That's to be paid 60 days. I'll make it 90 days after release.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the People versus Juliet von Oceanbear Martinez. This is Mr. Siller's case.
Conrad Siller on behalf of Pittsfield Township.
All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse counseling the court deems necessary. You understand that?
Right.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't
Is it
necessary.
necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez,
Yeah.
are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court, a court on any other things?
I am. But none of them are drug related. And they're about to be finished.
Well, maybe. What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like have it like
To do what?
have it go like is there any way to like forget about this somehow? Is there anything that I can do like community service or something that I could do instead of
Mr. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, knowing a little bit about your history, I don't know that would be a wise call on your part.
guess so. Like what like I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like I can have this be adjourned with a bond. Can I know what the bond is?
Mr. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
No.
So
I'm not protesting to the allegations. I would like to
well,
just.
hold on. I don't want you saying anything about the offense.
Well, I do. I see no way around it. It's plain and clear and simple. And
Well, I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
but it's clear, it's plain. Like,
Well, I don't know that, Ms. Martinez.
yeah, I guess I'll go with the lawyer, sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them. So I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that. All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So I believe it's the 28th.
Okay. So what I will do is I'll adjourn this matter out to August 6th, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Thank you, Your Honor. Thank you, Ms. Martinez.
I'll be done. It says on the Forensic Center is coming to see me today.
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez. But you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pate. Thank you.
All right, thank you.
Thank you, Ms. Martinez.
Court does call the case People versus Eric. Is it Canis? Case AC?
That's one of the people. Raise it, Your Honor.
Hello, Your Honor.
Hello, your name?
Eric James Casey.
Sir, you're here on an arraignment on two charges. The complaint alleges that on or about July 18, 2024, at the location of
this courthouse.
33.
Yeah, it all happened in this courthouse.
Are you going to interrupt me?
I'm sorry.
Are you going to let me continue with your arraignment?
Okay, I'm sorry, sir.
Which way you want to do it?
I'm not going to interrupt you.
Thank you. Complaint alleges that on or about July 18, 2024, at the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, complaint alleges that you did make an assault and battery upon a Joseph Crossley. Do you understand the nature of that charge, sir? And I'm not asking you whether or not you did it. Do you understand what you were charged with?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. This could be a consecutive sentence. If a consecutive sentence can be imposed, if this did occur within a place of confinement, you understand the nature or the penalties in this case?
Yes.
You understand that?
Yes.
Count 2 on that complaint alleges that on that same date and at that same time, you did commit the offense of disorderly person jostling. Do you understand the nature of that, sir?
No, because I don't even know these people. The only person I know is Joseph.
Do you understand what you are charged with?
Well, I know what you're charging me with, sir, but
I am not charging you. Do you understand what you are charged with in count 2?
No.
All right. Let me just do it formally then. July 18, 2024, the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Count 2 specifically alleges that on that same date and at that same location that you were a disorderly person. To wit, a person was found to be jostling or roughly crowding people unnecessarily in a public place at that location. Do you understand all of that?
I understand all this.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand those penalties?
I understand this, Honor.
Do you wish to be represented by an attorney?
Yes, I guess so, Honor, because you didn't let me
Public
speak.
defender case.
Assistant Public Defender Natalie Pate and on behalf of Mr. Casey, we would waive any further reading. My client stands mute and we would ask for an adjourned pre-trial date as well as a PR bond, please, Your Honor.
Defendant having waived for reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to July 16th, 2025 at 9 a.m. I will set the defendant's bond in this case, amount of a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. Do you understand that, sir?
Oh, yes.
Do you understand also that I am going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug?
Yes.
I will also order that you are not to have any contact whatsoever with Joseph Crossley.
Don't want to. I'm sorry, sir.
You are really wearing on me.
I'm sorry, sir. I'm just trying to.
Do you understand the order? That was a question. Do you understand you are to have no contact with Joseph Crossley?
Yes. I haven't had no. I'm sorry. I'm sorry. I'm sorry.
He gets one more time.
I'm sorry.
I'm changing the bond.
I'm sorry.
Is there any other requests of conditions from the people?
There is a request for a no go to, Your Honor, an address. May I give that to the court?
No go to, yes, go ahead.
10245 Talladay Road, Talladay in Willis, Michigan. 48191.
Nope.
Any objection to that, counsel?
No, Your Honor.
All right, I'm going to order that there is no go to that location, 1025 Talladay Road, Willis. Thank you.
Thank you.
Thank you.
Sorry, Judge.
Court calls case People versus DeMar Ficklin.
That's one people.
Hello.
My name is DeMar Ficklin.
All right. Sir, this is an arraignment. You are before the court on a complaint that alleges that between the dates of October 4th, 2024 and October 18th, 2024, at the location of 3825 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Myers store, that you as an agent or trustee of that store did embezzle funds greater than or less than $200. You understand that charge, sir?
Yes.
All right. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become your maximum fine. You understand that? Yes. Okay. First question I have for you: do you wish to be represented by an attorney?
Yes.
See how easy that can be?
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Ficklin. We will waive further reading, stand mute, and ask for another pretrial date, Your Honor.
Defendant every way for reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned July 16th, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. All order standard conditions, including no assaultive behavior or possession of any weapons. I'll also order that there's to be no alcohol, no recreational marijuana, or any illegal drugs. You understand that? Yes. All right. I will also indicate that the defendant is not to go to the 3825 watch I'm gonna order he's not to go to any Meyer in the state of Michigan. You understand that, sir?
Yes.
All right. Anything else?
No, Your Honor, thank you. Nothing, thank you.
All right. Who's here with you? Who's that?
My mom.
Mom? So after that last gentleman came up and your mom knew you were coming up for arraignment, did she tell you how to act?
Yeah.
She did? And she probably said, don't do that?
Oh, yeah.
You got a wise mom. All right, thank you. Thank you, ma'am. Court does call the case People versus Kenneth Miller.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Miller. Mr. Miller, please state your name for the record.
Kenneth Miller.
All right, thank you, sir.
Your Honor, we are requesting an adjournment for potential mitigation information to Ms. Londy. I would ask maybe for a little bit further than the 16th if possible. Mr. Miller is engaged in treatment.
Got it. Adjourn this to August 6, 2025, 9 a.m.
Thank you, Your Honor.
Your Honor, may
Yes,
I
sir.
ask a question? I was wondering if if it would be possible to switch to the sober link from the tether. Because it's impeding me from being able to let my kids go to the pool because I can't get in to save them if they're gonna drown.
Wow. I'd have to hear that by motion or if it's arranged by stipulation of the people. But, sir, the alleged BAC in this matter is a 0.21 and there was a crash. So it's unlikely that I will be changing that.
I'll also note for the record, Your Honor, there was a 6-year-old in the car.
Yes. All right.
I'll speak to my client further about it, Your Honor. Thank you.
Thank you.
Thank you.
Nicole Farr. Your Honor. Just trying to read your file here. Okay, on the record in state of Michigan versus Nicole Farr, 2200953FY. And you are Nicole Farr?
Yes, ma'am.
Okay. Ms.
Assistant Public
Farr,
Defender.
looks like, yeah, Mr. Hart, I didn't know if you could be appearing in this because it's a collections file.
Oh, okay.
Ms. Farr was arrested for something else last night, but apparently they have not authorized charges for that yet. So it's just collections.
Okay.
Okay. Ms. Farr, this is an old file apparently for which you have a balance due. According to the clerk, gosh, this is old, so I'm not 100% sure. I have to look it up. Last I knew, it said that you owed $562.08. I think that might be right, but let me make sure. Oh, okay. There's a bunch of files here. I have to add them all together, I guess, because
Bill is
actually
207.
there's 562.08 in this file, and then you have like 1, 2, 3 expired meter tickets at 108 a piece, and then 108 times 3. Then you have 2 handicap parking tickets at 186 a piece. So if we really add that up, it's $1,258.08. That's everything. It looks like you were supposed to set a payment plan in March of 2025. You didn't, I guess, follow through on that. There was, they scheduled you for a show cause hearing April 22nd, 2025. Looks like you might not have shown up for that. They set you for an arraignment June 23rd of 2025. Again, didn't show up. So I guess, Ms. Farr, I guess I need to verify firstly that we're sending things to the right address. What is the correct address for you?
404 East Sheridan Road, Michigan 48906.
Okay, so we're using the right address. Why aren't you taking care of addressing the court on this?
I've been in the hospital, ma'am, 15, this is going on my 15th time, and my son is in need. He needs a blood transfusion. Yes, ma'am. His dad
Okay.
is using and abusing his federal money, and I owe 207. And I
No,
ran
you-
my social security paperwork.
You don't. You owe $1,258.08, and you need to come in here and set up a payment plan on this.
I'm Erin Dwayne Carlisle's mother. Yes, ma'am.
I don't know what that means.
I want an Amber Alert on Damian Cortez Carlisle Senior. He is using and abusing my son, and Aaron is rotting from the inside out. He has bed bugs, parasites all over his body.
Ms.
Ma'am,
Farr, you can make a police report on that. Right now, all I'm talking to you about is you
I've been
setting
in
up
here
a payment plan.
privately. I've been in here privately, ma'am. I have my paperwork on my right side. Yes.
So all I want to talk to you about is setting up payment arrangements on all this money you owe.
His dad is abusing it, ma'am. I'm gonna have medical
Yes,
records.
you make a police report on that, but I can't address that for you. I'm sorry. Ms. Farr doesn't seem competent to have this conversation today. Ms. Farr,
I'm listening. Right
no,
now.
we're trying to talk about payments and you seem to not be able to connect with me about payments. Ms. Farr, are we gonna set up a payment arrangement or do something about all this money you owe that you haven't been coming into the court to talk about?
I would like to set out an Amber Alert. I'm here
Okay, that's
privately.
not related.
I'm here privately for myself and my son.
Are you a CMH consumer?
Yes, I've had 14 hospital visits, ma'am. I have medication.
Are you under a current treatment order?
Nope, I take my medications as prescribed.
Yeah, I'm just wondering if you need some assistance with that, because at the moment, you seem to be a little bit disconnected from what we're trying to do here. When's the last time you went and saw your treatment provider?
That was 6 months ago.
Okay, did you miss an appointment?
Oh, I turned myself in on a personal recognizance bond, 5/23/25. I got accepted into LCC college.
Uh-huh. Okay, I'm going to pass this matter and see if CMH wants to come talk to you, because it seems like you're unable to have a conversation about this.
I'm my own representative, ma'am. I'm here.
Yep.
Picked up.
Okay. To the jail, if I get information back from CMH, we can maybe see her later, or she'll have to see the magistrate tomorrow, but I'm trying to get info from CMH for her. Okay. Thank you so much. Thank you.